I am Kelly Kermer and I'll be your instructor for this class. Throughout the semester, I will be posting different video snippets that will provide a little bit of lecture on some very specific topics. As I'm recording this, you might hear barking in the background. Those would be my two labs that can't always seem to control themselves. So I will do my best to minimize the distraction, but oftentimes they will have to speak up every once in a while. For today's topic, I wanted to talk about the constitutional powers that the government has, as well as limitations on those powers. As you're reading through the chapters in these beginning modules, you're going to see that the body of the Constitution, specifically Articles 1, 2, and 3, actually empower the government. And so when we're looking at those constitutional powers, we're going to be looking at the different types of breakdowns of law within the government structure. And so I'm pulling up a PowerPoint here, which I hope that you all can see. And it really brings us back to our high school times. And during high school, you remember talking to your teacher, and the teacher would say, you know, there are three branches of government and there is a balance of power. And that's absolutely true. Article 1 of the Constitution empowers the legislature, which is Congress, and Congress's job is to pass laws which are called statutes. The executive branch of government traditionally has the responsibility of enforcing those laws, and those powers are derived from Article 2 of the Constitution. And then the judiciary is created through Article 3 of the Constitution, and it interprets the laws. In addition to the jobs of passing laws, enforcing laws, and interpreting laws, each branch of government actually has a role in creating laws. Obviously, the primary goal of the legislature is to create laws, but the executive branch, through its administrative agencies, will frequently create laws like administrative regulations. So, for example, the administrative regulations are created by the Occupational Safety and Health Administration of the United States government's executive branch. And under the powers of the executive branch, the administrative agency can create regulations related to health and safety in the workplace. So those are examples of laws that are created via the executive branch. The judiciary, in issuing its decisions under the doctrine of stare decisis, creates common law or case law. So Supreme Court decisions, for example, are binding upon us as citizens and other courts. So when the Supreme Court issues opinion, it also becomes the law of the land. So while the Constitution of the United States empowers the federal government branches, we also have our state system. And the federal Constitution allows the states to create their own constitution and their own branches of government. The state constitution in Maryland is actually the Maryland Declaration of Rights. And under the Maryland Declaration of Rights, we have the same three branches of government with the same powers to make, interpret, and enforce laws, and our executive and judiciary also create laws in the form of administrative regulations and common law, just like the federal branch. Of course, when we have the United States government and the state government, there may be conflicts in the types of laws that they issue. So there are two concepts that you always want to remember with regard to federal law and state law. First of all, that if the state and federal law conflict, the federal law will always win. It essentially trumps out the state law. So the state law is superseded by the federal law. Now, sometimes the federal government may disallow states from making any type of law whatsoever on specific topics. And in those situations, when the states are prevented from making any laws whatsoever, that's considered preemption. So some examples where the states are preempted and they're not allowed to pass any laws whatsoever or be in the business of certain types of lawmaking, some of those examples would include immigration law, or it may include bankruptcy law. If we look at the example of immigration law, imagine that each state along the border with Mexico had different state laws regarding immigration. The immigrants would be flocking to the borders of some states that had easier immigration laws than others, and it could be quite overwhelming. So the United States government has decided that it shall be the only regulator so that it's uniform across the entire border with other countries, and therefore the state laws on those issues are preempted. Now, while the Constitution gives the governments the power to do things, when the framers of our Constitution created the government and gave it all of these powers, it was a little bit afraid. And essentially it said, we're concerned that it has so much power it may infringe upon our basic rights. And so the Bill of Rights were created. And I promise to you that this statement is absolutely true, and I think you've read about it in your text. Essentially, the Bill of Rights does not give any people, you, me, or any other U.S. citizen, any rights whatsoever. So I ask, why is that statement true? Well, essentially, the statement is true is because the law and the Constitution recognized, and especially our framers, recognized that we had basic unalienable rights. And essentially, what the Bill of Rights does is that it only protects the citizens from government interference on those rights. It doesn't create those rights for us, but instead it tells the government it cannot infringe upon it. It does not have the power to do so. So if you read the specific language, for instance, of the First Amendment of the Constitution doesn't say you have the right to free speech or the right to freely exercise your religion. Instead, it actually says Congress shall make no laws respecting the free speech or infringing upon our free speech. And so in that situation, it's telling the government what it's not allowed to do. Throughout the course of this entire semester, we're actually going to always be asking the question, does the government have the power to do something? So in the beginning chapters and modules in this session, of the semester, we're going to be talking about where does the government get the power. So does Article 1 give Congress the power to create something like the American Care Act, also known as Obamacare? Does the government have the power to create different types of administrative regulations? Does the government have the power, such as in Marbury versus Madison, for the courts to issue essentially the final ruling on the laws of the land? And so that's what we're going to be addressing at the beginning part. But then after we do that, we're going to be saying, are there limitations on those government powers? And in determining if there are limitations, we will be using different standards of constitutional scrutiny. And those different levels of constitutional scrutiny include strict scrutiny, middle level scrutiny, and the rational basis test. So when we deal with the strict scrutiny test, we're going to be applying that in two different circumstances. The strict scrutiny test will be applied when we deal with fundamental rights and freedoms, such as our free speech rights or our free exercise of religion, or it'll be applied to determining if the government is unlawfully treating members of protected classes differently. And so is the government discriminating against other people in an unlawful and unconstitutional way? Well, let's first look at our fundamental rights and freedoms. For example, free speech. So free speech is one of our basic rights, and it's one of the things that we cherish most as U.S. citizens. We hear about things in other areas of the world, such as limitations on access to the internet, social networking, and simply being able to speak out against the governments. I always feel very fortunate about our free rights here in the United States. However, there are certain instances where the government can limit our free speech rights, and those are only in circumstances where there is a compelling government interest and there is no less restrictive way to achieve that interest. And when we look at a compelling government interest, it has to be very, very, very important, a really great reason for the U.S. government doing that. So let's look at the case, for instance, of child pornography. We have to ask ourselves, does the government have the power to criminalize the possession or making of child pornography? And you would ask yourself in the context of, does the government have the power to do that, and analyze it under the strict scrutiny test because it's a fundamental right or freedom. Therefore, we would say, does the government have a compelling interest, and is there no less restrictive way than a complete ban on child pornography whatsoever? Well, the argument that has been adopted by the Supreme Court is that, yes, the government does have a really great interest, and it's to protect children from sexual exploitation, and that no one can make child pornography really without supporting or promoting the exploitation of children. And therefore, that is a really, really good interest that the government has to protect children. And a complete ban, the Supreme Court has determined, is really the only way to do that. Because if you allow some children, perhaps of 16 or 17 years old, to be exploited, they would still be exploited, and a complete ban is absolutely necessary. Another example when we would apply the strict scrutiny test is when we're dealing with governmental discrimination based upon someone's protected status. Usually when we're dealing with a protected status, we consider that a suspect class. And suspect classes of individuals are individuals that have immutable traits, such as race or national origin. And based upon those immutable traits, the groups have been historically disenfranchised. And so the historical disenfranchisement is essentially that they've never really had political clout to the same degree as other races, such as the Caucasian race. And disenfranchisement also means that they haven't always had the right to vote. So if we think about it, African Americans have not always had the right to vote in the United States. And you can't change your race, and therefore it is considered a protected class. So if the government would decide to discriminate on the basis of a protective class, then we would apply the strict scrutiny test. An example of this would be Japanese internment camps during World War II. So in World War II, because we were concerned that Japanese were attacking in Pearl Harbor and we were at war against Japan, the United States decided that everyone of Japanese origin within a certain degree of generations, or first generation Japanese Americans, had to be imprisoned essentially in what were called internment camps. And they were imprisoned simply because of their race, and they might possibly be a threat to the U.S. Well, the court looked at the case and they said, well, clearly this is discrimination based upon someone's race or national origin here, really, because they're from Japan. And based upon that national origin, they're being treated differently. They're being imprisoned. Is there any least restrictive ways to doing it? Is it that compelling interest of protecting our national security? Is it narrowly tailored to that? And the court said certainly not everyone of Japanese descent is going to be hostile to the U.S. As a matter of fact, many people of Japanese descent are very loyal to the U.S. and would be fighting for the U.S. given the opportunity. So therefore, it was not narrowly tailored to that important homeland security interest, and it was not considered to be constitutional. So those are some examples of how the strict scrutiny test is applied. Next, I'm going to talk about the rational basis test, and I'm going to be skipping over the middle level scrutiny for a second. With regard to the rational basis test, this is when we're dealing with non-fundamental rights or freedoms and non-protected classes. So for example, the government issues a regulation that requires you to wear a helmet while you are riding a motorcycle. The government's rational reason for infringing upon your right to not wear a helmet is rationally related to the fact that it wants to reduce head traumas and reduce government expenditures on medical care of people that are severely injured in motorcycle accidents. And so, yes, that does infringe upon a right, but is the right to not wear a motorcycle helmet a fundamental right, like free speech or the free exercise of religion? Is it an inalienable right that we were born with? And the answer to that is no. So the rational basis test applies, and simply the government has to have a good reason and not a great reason for infringing upon that right. Now, another example of when the rational basis test would be applied might be to someone's young age discrimination. So, for example, people over the age of 21 in the state of Maryland can drink alcohol, but people under the age of 21 in the state of Maryland cannot drink alcohol. Clearly, we're treating two different groups of people differently because of their age. In this situation, age is not an immutable trait. We are going to get older over time. Therefore, age is not a protected or suspect class, and strict scrutiny doesn't apply. So therefore, when we apply the rational basis test, the government only has to have a good reason and not a great reason for allowing minors or disallowing minors to drink alcohol. And that rational reason could simply be something in that minors' brains are still developing and alcohol could impair that development, and therefore we want to protect kids from any alcohol-related brain damage that could occur. It may not be the best reason in the world because everybody's brains may not be developing at the same rate, but it doesn't have to be a great reason. It just has to be a good reason. Now, when we look at middle level scrutiny, that is a very unique standard, and it's only applied by the federal government with regard to gender discrimination or treating people of a different gender differently. And it's quite interesting because the United States Congress and its citizens have never passed an Equal Rights Amendment, which would give gender the same protections as those in a protected class or status. There's a kind of a disconnect in understanding the concepts of protected statuses because we look at an immutable trait, and really until recently when you could have gender reassignment surgery, that trait was really truly immutable, but at the chromosomal or gene level, your gender will always be dictated there, and that can't be changed, at least at this point technologically. And also, women were historically disenfranchised. Women didn't gain the right to vote until after African American men were allowed the right to vote. So even though they've been historically disenfranchised and they have what really is at the heart an immutable trait, gender has been treated differently by the U.S. Supreme Court, and they apply a middle level of scrutiny to determine if the government has the power to treat people differently on the basis of gender. And under the concept of middle level scrutiny, the government only has to prove that there is an important government interest, not a great interest and not a just okay interest, but an important reason to treat people of different gender differently. So let's look at the example there of the draft. The males in this class that are over the age 18, most of you are probably all registered for the Selective Service, but the females in this class who are over the age of 18 probably never registered for the Selective Service because the federal law only requires men to register. And so you have to ask yourself, really, is this constitutional? Well, first, yes, the government is treating men and women differently, but is it okay to do that? And under the concepts of middle level scrutiny, you would have to say, does the government have an important interest in doing that? Well, the government certainly would have an important interest in making sure that it could field an army if necessary. But you would have to say, well, couldn't they draw an army from both genders? If I were a man, I would certainly be a little upset that, hey, I had to register for the Selective Service and, the other women of the same age as me didn't have to. But because it doesn't have to be a great reason, or narrowly tailored to that great reason, like a strict scrutiny test, the government in showing that it only has to have an important interest, such as protecting the nation, it doesn't have to show that there's a better way to go about doing it, and therefore having a one-gender draft might be considered constitutional. So I hope that this discussion of the governmental powers and the application of the strict scrutiny test, the middle level scrutiny and rational basis test has been helpful to you, and I would be happy to answer any questions you may have on this. Have a good day.